Good morning, everyone. I would like to mention, I'm going to depart a little bit from these two recent topics on copyright and move on to a different principle. However, not entirely, because one of the cases I will explain a little bit is on the application on copyright. Now, the principle of exhaustion, unfortunately, there is not a multilateral consensus on this particular principle. As we will see later on the international framework, it has been left open to the countries. There's national discretion; they can choose their own approach. But nonetheless, I will first explain a little bit what this principle is about. It is quite complex. But I will try to explain it as simple as possible as a frame to the recent case law in the Court of Justice of the European Union. I will touch upon the international framework, as I said, with the caveat of there is not much international legal framework. But fortunately for you, the European Union has established quite a few elements of this principle already in the regional legal framework, so I will touch upon those as well. Now, I will end my presentation, and most of my presentation will be about these recent two cases. One is on trademarks. Professor von Mühlendal yesterday already mentioned one, which is the most recent one and most relevant for trademarks. But I will also mention another one which is applicable for copyright. Now, what is this principle of exhaustion? So the theory of exhaustion is considered to be a creature of German law. The German jurist Joseph Kohler developed this principle applied to patents in the late 19th century. Later on, it was expanded to other intellectual property rights. And now it has been developed in most legal systems. As I said, since there are no international standards, there's quite a variety of approaches to this particular principle. Even the terminology might be different. For example, in the United States of America, it is referred to as the first sale doctrine, not as the exhaustion principle. Now, in order to explain it in a simple way, I find that the definition that has been, or the explanation that has been given by two professors, one from the United States, one from New Zealand, Professor Daniel Gervais and Professor Susie Frankel, they explain this in a very illustrative and eloquent way, I find. And for those of you who don't know it, this principle too much, I hope this is a clear way to explain it. He says, in any jurisdiction, there is always the question of how an IP right survives a transfer of ownership of an object that embodies this IP. So as we know, the IP is an intangible property right, and it frequently here is important for my last case that I will touch upon on copyright, it frequently finds a host in tangible goods or objects. Now, the principle of first sale, as it is referred to in the United States, is broadly referred to as when a purchaser buys a product, it doesn't really purchase the IP right that is embedded in that product. However, that first sale that has happened, what it does is it exhausts the distribution rights that the IP owner has on that good. Now, let me give an example, an easy one. If I go and buy a car at BMW, I am buying a good that embodies quite a few IP rights. So it has the trademarks, it has the BMW trademark, it has patents, industrial designs, and so on. I can, of course, the moment I buy that car, I can sell it immediately as a used car, and BMW cannot oppose to that further commercialization or that subsequent transfer. Now, this is in principle, and this is due to the fact that the original owner still owns the IP rights that are embodied in that object, but in principle, it has exhausted its distribution rights. Now, as I said, this is a fairly easy example. It doesn't make justice to the principle and its complexities. And there's a few elements that make this principle a bit more complicated. One of them is the territorial boundaries of this first sale and the subsequent transfers. And this touches upon what happens with importation of goods as well, with pricing, and there are a few elements that complicate this principle. But this is, and as I will mention later on, there is no international standards on this. So it is a policy decision that countries have to make. And there are quite a few approaches. Mainly, there is an international approach. The international approach, countries, what they say is the distribution or the resale right is exhausted once that good has been put in the market anywhere in the world. So it doesn't have to be placed in the market in that specific jurisdiction. It can be placed anywhere in the world. That means that the purchaser or a company in that country can import those goods and resell them in that specific jurisdiction. Now, a different approach is the national approach. In the national approach, countries, when they have chosen this approach, what they say is the distribution right is exhausted once that good has been sold on the market of that country only. So it doesn't matter if it was a good that has been sold in, let's say, France, and I am from Costa Rica. If it hasn't been yet put in the market in Costa Rica, it cannot be sold unless there is an authorization from the IP owner. Now, this policy consideration has many implications, socioeconomical implications, as I said, on international trade, on pricing, on consumer protection. I won't delve into these repercussions. The European Union has, for already almost 20 years, have already chosen an approach, which is the regional approach. They have, in the European Union, it means that once this good has been sold in the European Economic Area, the distribution rights are exhausted. This means also that the goods can have freedom of movement within the European Economic Area. Now, another element that is important, and as I said, these distribution rights are in principle exhausted, is that there may be legitimate reasons for the original owner to oppose further commercialization. Now, an example is if the conditions of the goods have been changed or impaired after the first sale. And as I will see later on also in the European Union, there is already a provision, and one of the cases, which is the SodaStream case that was mentioned yesterday, touches upon what actually legitimate reasons can be. Now, in the international legal framework, as I said, there are no standards, there is no harmonization. It is up to the states to decide freely which approach to take. We have the trade-related aspects of intellectual property rights agreement, known as the TRIPS agreement, in which WTO member states agreed, as I said, to national discretion. This means that countries are free to choose their own approach. It has even been left out of the dispute settlement mechanisms that are in the WTO, as the fact, since it is left to the countries to decide which approach, and therefore it is not covered. Now, as well, in the WIPO administered treaties, so in the IP treaties, there is no standard either. So this makes it, again, as I said, difficult, as there are a myriad of approaches and fragmentation of this principle. Now, on the European Union, as I mentioned, it's been already quite a few years where it has been established that it adheres to a regional approach. This is derived from the provisions in the Treaty on the Functioning of the European Union and the European Economic Agreement, as well as case law. There is this famous case, the Silhouette versus Hartlauer, where the Court of Justice of the European Union held that the EU member states were not free to have an international exhaustion regime, and that they must have the European Economic Area regime only. This case was related to trademarks, but it has been settled that it applies to other IP rights as well. It is now also being recognized in various European Union directives and also implemented into the legislation, the domestic legislation of the European member states. Now, as the two cases I will explain later on, one is on copyright, one is on trademark. I will focus on these two specific IP rights. As I said, this principle applies to basically all IP rights, and patents, for example, has quite a fascinating case law as well, but I will focus on trademarks and copyright. So for trademarks, we have the trademark EU regulation. For EU trademarks, we also have the directive for national trademarks, and this principle is both enshrined in these regulations in Article 15, where both recognize that the exhaustion applies once the first sale has occurred anywhere in the European Economic Area. As well, we have in paragraph 2 the recognition that the trademark owner may oppose further commercialization of those goods when there are legitimate reasons to do so. As an example, and as I will see later on, it doesn't give an exhaustive list of what are these legitimate reasons. However, it does say it can be, for example, if the good has been changed or impaired after the first sale. And I will explore this when I get to the SodaStream case. Now, in the case of copyright, it has also been already recognized in the directives, in the software directive for software and in the IPO directive for traditional works. One thing to mention about copyright is that it is clearly recognized for the distribution rights of the copyright owner. So as you may know, copyright owners have a myriad of exclusive rights, including adaptation, performance, etc., which require the authorization of or consent of the author in order to exercise those rights. Those are not exhausted with the first distribution or the first sale. So the only right that is exhausted with the first sale is the distribution right or the subsequent transfers of this work. Now, moving on to the two cases that are the most recent one in the European Union about this principle, one on trademarks, one on copyright. I will start with the one that was mentioned yesterday, the SodaStream case on trademarks. It applies specifically to reusable and refillable products, which is quite an important decision in the trend of circular economy at the moment. And as we will see, it touches upon the problematic of what are the legitimate reasons of the IP owner to oppose further commercialization. The second case I will explain is the Tom Cabinet case. This one is a bit older. It's from December 2019. However, it remains as the most recent one in this area, and it touches upon a delicate question, which is the digital exhaustion. As I had said in my first slide of the defining this principle, the IP rights are intangible goods that frequently find an object to be embodied. In the digital world, that premise is put into question because we can have IP rights that are circulating, but there is no tangible good that is embodying these rights. They're just there in a cloud, you download it, you upload it, there is transfer, there are different people that have access to it. So what does this mean for the exhaustion principle? Now, the SodaStream case, it was mentioned yesterday, so I'll try to be brief and just go into the specifics of the legitimate reasoning. This relates to two companies that produce and sell carbonating machines. I don't know if you own one. I have one at home. They're great. You can, from tap water, just produce these flavored carbonated beverages. They require a a gas cylinder, which of course the gas runs out, so this gas cylinder has to be replaced, has to be refilled, something has to be done with that gas cylinder. Now both companies sell these gas cylinders, they're compatible with all the machines. However, these gas cylinders, the gas cylinders of SodaStream, they have, and this is an important point, they have the label that you can see on the screen there on the left, where it has the trademark, it has information, etc. But SodaStream also engraved in the body of the aluminum gas cylinder the trademark, both at the bottom, both at the top. So it has the label that can be replaced, but it also has engraved the trademark at the bottom and the top. Now My Soda, the other company, what they were doing is they were receiving used gas cylinders inclusively from SodaStream, from consumers. They were refilling them with gas. They would replace the label with, as you can see as well on the screen, with a different label with the information about My Soda, etc. But they were leaving visible the engraved trademark at the bottom and the top of the gas cylinder. Now this, of course, made SodaStream not very happy. So this is a Finnish case. So SodaStream brought an infringement action before the market court in Finland, this went all the way up to the Supreme Court, and the Supreme Court referred this case to the Court of Justice. Now, the Supreme Court asked 4 questions. As a practice, I guess all of you know, the Court of Justice can reframe and just reformulate and be very creative on the way they treat these questions. So they did this in this particular case, and they reframed it into a fairly simple question. They said whether, and if so, under what conditions, the trademark owner, who has already put on the market in one of the EU member states goods bearing that mark, and that are intended to be reused and refilled numerous times, is entitled under EU regulations to oppose further commercialization of those goods by a reseller who has refilled them, replaced the label, but then left visible the original mark on those goods. Now, there has been a case law on reusable goods, so this is not an entirely new case on this regard. The important question here was about the visible mark that was left on the gas cylinder. It was not about just refilling and replacing the labels. So the court referred to this case, the Viking gas, where it confirmed that in principle, selling a refillable gas cylinder exhausts the trademark's rights. So what the court explained, it says, the moment that gas cylinder is sold, this exhausts the trademark rights, and it transfers to the purchaser the right to use that cylinder freely. So the purchaser can refill it, exchange it, do whatever it wants with that cylinder. Now that consequently means that the competitors can receive those cylinders and refill them. They can also exchange the empty bottles. So it is kind of a consequence of that exhaustion. However, and this is not new, the trademark owner may oppose further commercialization where there are legitimate reasons to justify this opposition. As I said, this is enshrined in the EU regulations. However, what are those legitimate reasons? There is no answer in the regulations, so this is left to the Court of Justice to interpret. Now, in this particular case, what the Court of Justice said is basically, if these new markings, create a false impression among consumers that there is an economic link between the reseller and the trademark owner, then this may amount to legitimate reasons to oppose further commercialization. Now, how do you know if there is an impression among consumers that there is an economic link? So how do you assess that? Well, the court gave some indication and direction on how to do this. They said, in order to assess this, there must be all circumstances relating to the reseller's activity must be accounted for, so it should be a global assessment. So first of all, the extent of the information that appears in the new label is quite significant. It gives, of course, the information to the consumer on who is the trademark owner. So the well-informed and reasonable observant consumer has to know that there isn't a connection between the reseller and the original trademark owner. But it's not only about that, it's also about the practices in the sector concerned. So how do the consumers get to refill these cylinders? Do they go directly to the reseller shop and they go with an empty bottle and in the shop they give them a new one with new labelings and they can see maybe this is a different company, or they go to a supermarket where they just have a lot of cylinders. They don't know where is it coming from, who is actually the owner. So there is this practice in the sector that is important to understand what is going on in the consumer's mind. And this boils down to whether the consumer is aware that the goods are reused by other operators that are not only the original trademark proprietor. And so you can see the Court of Justice established a few criteria. I checked whether the Supreme Court of Finland has already issued a decision to see how they actually applied this criteria in this particular case. However, so far they haven't yet done so. I find it surprising because this was a decision of October of last year. So I wonder what's going on in the Supreme Court, whether it has been difficult to establish what are the practices in this particular case. So we will yet have to see. Now, my last case I wanted to present today is about particularly copyrights. And as I said, it's about digital world, which can get quite complicated. Now, before delving into the specifics of this case, it is essential to provide some context and elucidate the legal landscape within which this case unfolded. So in the realm of tangible items, where there are physical books, where there are CDs, the Court of Justice has already firmly established that once this analog copy of a work has legitimately been distributed within the European Economic Area, by or with the owner consent, then the distribution right is deemed exhausted. This has been also enshrined, as we saw in the Article 4 of the InfoSoc Directive. As I said as well, this applies exclusively to the distribution rights. So other exclusive rights, such as performance, adaptation, reproduction, etc., those require the authorization of the copyright owner even after the good has been put into the market. Now, when we move into the digital era, this has, of course, introduced a level of complexity because words of intellectual property or intellectual creation, such as music, literary works, can be stored and transmitted, downloaded, uploaded through the cloud without the need for a physical carrier. So this was, as I said, one of the key elements of exhaustion. So how does this work in the digital world where there is no physical carrier? So this raises pertinent questions. So can the act of handing over a physical book can be treated the same as downloading an e-book to the computer? Should the exhaustion principle apply in these circumstances? Or what should be the conditions for this? Now, in the case of computer programs, the Court of Justice already issued a ruling, the use soft decision, which I don't know if you're familiar with it, and it clarified that in the case of computer programs, the exhaustion can be applicable to the software when it has been lawfully made available for download. So it has already established that in the case of computer programs, there is no need for a physical carrier. This transfer, this first sale doesn't require a physical carrier. It can be just being available for download. But this question remained for traditional works. And this case, the Tom Cabinet case, was a perfect opportunity for a national court to ask the Court of Justice for some guidance about this principle. Now, briefly on the facts, this is a Dutch company. They operated an online platform which offered members, it was based on membership, second-hand ebooks via download. Now, Tom Cabinet either legally purchased them or received them as a donation from the members. The files also were watermarked, to certify that they have been lawfully acquired, and they were offered for download upon a fixed price. Now, some Dutch publisher associations represent Dutch publishers. They applied for an injunction at the district court in The Hague to stop this online platform on the basis of unauthorized communication of ebooks to the public. So these companies representing the Dutch publishers, they said, no, this is not you're not distributing, this is not about distribution rights, this is about communication to the public. So as you know, communication to the public is not exhausted once this ebook has been sold for the first time. You're not allowed to do this without the publisher's consent. Now, the district court referred the case to the Court of Justice of the European Union. Again, 4 questions were posed, not only about whether this is a conduct related to communication to the public or about distribution, but also how to apply the exhaustion principle in these situations. The Court of Justice, again, reformulated, only answered the first question. And in essence, what it said is whether the supply by downloading for permanent use an ebook is covered by the concept of communication to the public within the meaning of the directive, or that of distribution to the public as well as under the directive. Now, the Court of Justice concluded that the wording in the InfoSoc directive alone could not provide any answers. So in its analysis, it opted for a contextual theological interpretation of the provisions. It also set some economic considerations on how these 2 markets, ebooks, can work as opposed to normal physical books. It also referred to the recitals of the InfoSoc directive, to the WIPO copyright treaty to define these two rights, to the explanatory memorandum of the European Commission to base its decision. Now, in a nutshell, it answered the question by saying that downloading an ebook for permanent use is communication to the public within the meaning of Article 3.1 of the InfoSoc directive. Now, in the analysis, what it did is it drew boundaries between what is actually communication to the public and what is distribution rights, so between Article 3 and Article 4 of the InfoSoc directive. So let me unpack a little bit this decision. Now, if we look at Article 4 of the InfoSoc directive, there is a reference to the term of original and copies. So what the court did is it said that these specific terms refer only to copies that are put into circulation as physical objects. So therefore, the distribution right applies only to each tangible object incorporating an intellectual creation. So with that, it, let's say, solved the question, because it said if there is no physical carrier, then it's not about distribution rights. In terms of the economic analysis that it did a little bit about this, distinction, it said the electronic and tangible dissemination should always be treated differently. So the supply of a book on a material medium and the supply of an e-book cannot be considered equivalent from an economic and functional point of view. For example, the e-books do not lose quality over time. Physical books do. They get wear and tear. What this means is that the e-books are always perfect substitutes of the original copy. The exchange of used copies in the digital world as well does not entail much effort, much cost. And these features cause the ebook second-hand market to more likely affect the capability of the copyright holders to obtain appropriate reward than a second-hand book market. It also, which was one question that was in the mind of many, whether the same treatment would be given to computer programs, and it clearly said that an ebook is not a computer program, and it said that it's not appropriate, therefore, to apply the specific provisions of the software directive, and that the use of case contributes lex specialis. Now, having excluded the applicability of Article 4, the question remained whether this was then a communication to the public. So the court applied the criteria it has established in a previous case law whether downloading an ebook for permanent use met the two cumulative criteria set by the court to identify an act covered by Article 3. And this is whether it represented an act of communication and whether it was directed to a public. Now, the court considered that indeed this conduct of making available protected works for on-demand transmission to any interested person that would become a member to this online platform would meet the criteria for an act covered by communication to the public. So what does this actually mean for digital exhaustion of ebook supply via download? So after this decision, and as it stands in the European Union specifically, reselling of ebooks via download is a communication to the public that does require permission of the right holder and cannot be exhausted with the first sale or transmission. Now, this decision has been applauded by many. However, it has been subject to debate and criticism. And as I said, it's not that recent, but it still creates some debate. Some argued that the court applied a formalistic and very rigid approach that has the consequence of ending any hopes of digital exhaustion. Additionally, the fact that it applied a different approach to software and to traditional works creates unnecessary fragmentation in the system, which is, in the end, a copyright system, and undermines the effectiveness of the exhaustion principle, that it's about rebalancing between copyright, fundamental freedoms, competition, and consumer welfare. Finally, this decision did not address important questions that I know are being subject to debate as well, whether actually this digital work transfer is being done as a sale, or should be treated as a license, which has contractual elements. And this is an important conceptual distinction because it will have consequences on the restrictions that can be put in place by the copyright owner. So with this, I didn't realize I had already passed to the last slide, but I end my presentation. I hope these two cases will give some food for thought, and I'm happy to answer any questions. Thank you.
Okay. Thank you very much, Ms. Fernández.